registrar or the tax master will ask you is this much, why? So even before the respondent or the judgment debtor complains about the scale, it will first be the judicial officer. So one of the examples I wanted to give, and I don't know if it's good practice, is the case of Rocco Petroleum versus URA. If you've read it, and I read it some time back, it was about a case that involved about, the subject matter was certain, it was about 58 billion. The tax master awarded the lawyers in that case 5.8 billion as instruction fees. There's an appeal to the judge. The judge reduced that sum to 5 billion. And when the case went on appeal, the Court of Appeal reduced that money to 3 million shillings. 3. And the judge actually in the Court of Appeal, their justices said, according to the scale, first of all, it was a matter of legal interpretation. And according to scale, the lawyers were entitled to only 478,500 shillings. But then they felt pity for the lawyers and gave them 3 million shillings. And the court ordered that the lawyers should refund the client's money that had been paid beyond that. If I recall well, I think the lawyers had been paid about 3 billion. So they were supposed to return 2,977 million shillings. So we can see this attitude cropping up. I don't know if it's cropping up, but it's been there. We've seen where judges use their discretion. I don't know if they use it judiciously. And the judge revises a bill of costs and says, yes, I have seen the subject matter, but you were awarded that much. So I'm giving you 500 million. We're talking about a case of $45 million. Without justification, without any reason whatsoever. And they feel like, why should a lawyer earn that much for having handled a matter, sitting in your office and drafting documents? Moreover, you didn't even write the judgment. What did you do? So it's a big challenge. Yet, when people are reaching these conclusions, they forget that when clients come to our offices, they come desperately. A client comes, they really, really want your help. And then after that, the client will say, but what has this person done? Why should I pay them this much money? The judiciary is not helping you either as a lawyer. The rules and the principles are directed to favor the clients. So it's a big problem, but I'll address more of what I think we can do. So what is the law? Is this billing and costing regulated by law? Yes, we have the Advocates Act. We have the Advocates Remuneration and Taxation of Courts Act. Section 50, particularly for litigation, for contentious matters, it allows advocates to engage clients and draw or execute fee agreements. And Regulation 57 of the Advocate Remuneration and Taxation of Costs regulations provides that in matters and causes in the High Court, the advocate can charge a client according to the scale provided for in the schedule. But are these laws, do they help the lawyers in any way? Have you found that they have helped the lawyers? For the cases I've looked at least the ones that have been litigated, when it comes to fee agreements, I find that they have been knocked down by the courts. One, the courts end up saying, no, this is a contingency, or this is a charm party agreement and it's illegal, or it does not comply with Section 51 of the Advocates Act. I looked at the case that was recently decided by Honorable Justice Mubiru, Bianca Chihika and Company Advocates versus Fang Min. And this is what he had to say about such agreements. I'll just read it verbatim. He says, as a result of lawyers' special role in the legal system, contracts between lawyer and client receive different treatment than other contracts. The court's inherent authority to supervise and discipline advocates as its officers is well recognized. In this connection, it must be remembered that when an advocate enters into an agreement with his client, the advocate is not acting merely as a private person, but is acting as an officer of court. So fee agreements are accordingly subjected to judicial oversight and intervention. So, and we've seen it happen. that every time the courts have tested, I don't know about the cases where these agreements have been upheld, but every time they have come up, the courts will either find them illegal or, but as advocates, what are we also doing? Because the courts are right. Most of the times we do not comply with the provisions of the law. Have you registered your agreement? Has it been notarized? Has it been registered with law counsel? Is it unreasonable? Is it unfair? So most times when we enter these agreements, we also overdo it. You're representing a client, and because they have come to you without money, you want to charge them exorbitant fees at a certain point T. So I found that there's a problem there too. So we can safely say that, yes, the laws are there, but how we, the lawyers, use them and how the judiciary also looks at them, there's a bit of a conflict there. And one question that maybe everyone can go home with, in very many jurisdictions, charm party agreements have been allowed. They've been allowed. If a client has come to me in their right state of mind and they say, I don't have money, but maybe find me someone who can facilitate or sponsor my case, why then should it be treated as illegal? It's a question that you'll go home with, and maybe we'll discuss it some other time. So in view of these challenges, what are the modes of billing, and what are the strategies to knowing that people are not willing to pay by scale, but even then, knowing that lawyers are not that much favored in the industry. So what are the modes? One, I've already talked about it. There's signing of client fee agreements. Please make sure that your agreement complies with the law, at least if you have to sign one. Oftentimes, these agreements do not. So, but then these agreements, do the clients eventually comply? Especially when you've agreed that maybe the client will pay at a certain stage T, and you've passed, the case is in advanced stages. Do these clients actually comply? Because you're not supposed to sue on the agreement. You can only apply to enforce it. Then that becomes another litigation altogether. File submissions, do this, do that. So most times you find that, okay, I've done this, but why should I go into another litigation with a client who moreover doesn't have money? So the other mode is apportioning the fees to the stages of the case. You could apportion the fees. The client comes to you. You actually look at the scale, discuss with him, be open to the client, discuss with him or her or it, and apportion the fees to the stages of the case. Maybe you could say that at filing, you will pay this much. At scheduling or after scheduling, you pay this much. At submission level, you pay this much. And I think that keeps both the lawyers and the client engaged. The lawyer is happy. Every lawyer is happy to get paid at every stage. And it keeps the client feeling like, maybe I'm not being charged that much, but they're actually paying it. So that is another mode of charging. When I was looking at these modes, I looked at what they call the client satisfaction curve. And there's a gentleman called Funberg. He came up with a curve called the Funberg gratitude curve. He articulated a concept which came to be known as the Funberg gratitude curve to describe the correlation between the progression of a piece of legal work, the client's appreciation of work, and the willingness to pay. He set it against the timelines. So I'll ask you to kindly project the presentation. I just want to show you that curve because when clients come to us, their utility tends to go up, and at a certain level T, it's very high up there, and as time goes by, as the case advances, there's diminishing marginal utility. I don't know if that makes sense for the lawyers. So I'll just look. It's a very interesting curve. So we'll just look at it. So I don't know if this looks. Um, I'll just explain it from here. I know the words might not be so clear. So this is the Funberg gratitude curve, and as a lawyer, especially as young lawyers, you should learn it as you progress in the profession. So when the client first comes to you, they are desperate. I'm desperate. I need your help. There, you've not started. You're just getting to know the client, and in turn, the client is starting to get to know you. Then the client reaches the stage. Meanwhile, the curve is upward going. I'm glad I've got you on board. So as you continue to interact with the client, you go to the stage, this is going well, I'm really impressed by you. There, you know the client, you've gotten to know each other, you're familiarizing yourself with him. Probably you've even given some free legal advice here and there. Then we are so close, you're the best. Here, you're very familiar with the client. The client is very impressed with you. Then at one point, this person was being evicted from a property. Then you get them an interim order or a temporary injunction. My lawyer is a legend, and I'm going to tell everyone about him or her. So that is when the curve is at its best, at its highest. It's at that point when Funberg says you should charge the client. Because when you don't charge the client at this point T, then the curve starts to diminish. Now the person has an injunction. They are not evicting him anymore. I'm staying in my property, I'm earning from it. And therefore, the lawyer owns the case. When you call the client, we have court on Monday. I'm not around. But before they got the relief, the interim relief, every day, they would even come to, they're the ones that come to office before you. Then we got to, my lawyer did well, but I had an advantage anyway, right? I had a title. What do you mean? How could they evict me? My lawyer told me I cannot be ejected from the property because I'm a registered proprietor. Then you go to, my lawyer was helpful, but really a form filler, you know? Then as the case progresses, and I'm telling you here, the hearing is probably done. You filed submissions, judgment is pending. I really could have done this whole thing by myself, you know? So, and then that SOB is suing me for the fees. I'll lodge a complaint. Then the lawyer is so bad. You came to me, you were so desperate. We agreed, there's even a fee agreement, but at a certain point T, when the curve diminishes, at its lowest, that's when you find clients denying lawyers. Have you guys seen it? Yeah, you go to court and the client said, oh, no, I don't know that lawyer. At that stage, they have started hiring another law firm, and it's not bad to work together, colleagues. But now, why should I pay this person this much? So I think as lawyers, we need to learn the curve. Funberg was very generous to have given us this curve. So you need to learn at what point you should charge the client, having in mind that running a firm is, it's a cost-intense business also. So service provision is not easy. So knowing when to charge the client, when to invoice is very important. Then the other one is, there's the Ugandan litigation practice it's very common. It's not uncommon for people to file so many applications. You know, you file a suit, then there are application for amendment, application for adding a party, an application for temporary injunction, an application. Most times when we sit with the client, you don't actually address some of his applications because you don't know. It's uncertain that they'll come up. And most times I find, we face this problem, that some of these applications go away unpaid because the client doesn't understand the difference between, for me, I gave you my suit. I remember, I'll crack this joke in Luganda. Long time ago, a colleague of mine represented someone in a summary suit. So the person went away, and when they came back, the summary suit was not yet completed. And the gentleman said, Wangamba summary suit, Welcome to summary suit. You told me it was a summary suit. Why are we still in court after 4 years? You know, this person didn't know that there was an application. Then this person was allowed to file their defense, and it turned into trial altogether. So please learn to engage. I think we need to learn to engage the clients at every stage. Every stage of the case, you need to, the client must know, and I'll address this shortly after this. Then sharing costs at the end of the case. Most times, most times when the client gets a judgment, they are very satisfied. They don't care about the bill of costs. So you find that the lawyer actually owns the bill. And most times why they do this is because probably the client couldn't pay by scale. So they decided that they will handle the case, and that at the end of the case, they will share the costs. So there's also that. So what are the strategies of overcoming some of these problems that we're talking about? One, I looked at sign letters of engagement. Lawyers, please learn to sign, let's learn to sign letters of engagement. We've seen it. A client comes up and says, I don't know that lawyer. I actually never hired them. If they think I hired them, where is my letter of engagement? You know, there's a time I was in court and they called the case. My name is Natkunda, and the case was exactly the same name, Natkunda versus Natkunda, both names. So I was very intrigued, and I asked the clerk, it wasn't my case, and I said, how come the plaintiff and defendant are exactly the same? And this clerk tells me, no, Natkunda Jacqueline, the defendant, forged the title of Natkunda Jacqueline, the plaintiff. And I said, so does this person even know who the other Natkunda Jacqueline is? So if you don't sign a letter of engagement, and the client comes up and says, no, it looks like this lawyer is for the defendant. This lawyer is not my lawyer. I've never seen him, I've never hired him. So I think we need to learn to sign those engagement letters. We've adopted that strategy at the firm which I work. For every client, for as long as you walk in and we've agreed to take on your instructions, the first thing you'll do is write to us and give us formal instructions. The other thing, and this one is big, is please engage your clients. Let's learn to engage our clients, involve the client from inception of the case with litigation. If you're going to court to spend 6 hours where 10 cases have been allocated for hearing, let the client sit with you there. Because there's no way you're going to charge a client for spending 10 hours at court if that client was not there with you. We know the judges that, they schedule 10 cases at 9. All of them are for hearing. Then you don't only have one client, you have many, and you're in the court corridor seated. So if you don't engage your client from inception, and that's what I was talking about applications, when these applications come up, you have to engage them. For me, immediately when an application comes to me, one, I'll say I'm not a perpetual lawyer for the client. These lawyers that, I appeared for Mr. Sevgenya, and therefore in every case they have to serve me. Most lawyers take on those instructions because, he's my client, or they will assume he'll engage me. Maybe he doesn't want you anymore as a lawyer. Maybe he wants to explore other lawyers. So the first thing I do is say, okay, I'll take those documents, but I'll only send them to the client. And until they give me instructions, I'm unable to receive. So just because your application arises out of a suit, or there's another suit involving the same client, does not mean that I will always receive those documents, because I don't have perpetual instructions. The other thing is, do not own some of these. Let's not own these cases, You find a lawyer dying in court. Where is your client? My lord, I don't know. I've seen this in Honorable Justice Mubiru's court. He's always interested in knowing where the client is, So, let the client own their case. I'm here to represent you. When I cracked a joke with Mr. Chas this morning, and I said, have you ever seen a doctor treating a patient at home? You're the doctor in this case. You're the professional. So if the client will sit at home, watch football at 10 p.m., you're in office, you're drafting submissions. But the one thing that will stick in the client's head is that when you went to court, you only presented a few papers. They don't know that you filed submissions. They don't know what you go through to do this. So if you don't engage these clients, That's how we find that they don't want to pay. There's this question that Mr. Chaze always asks clients, and he says, I don't know, when did your case become mine? When did I turn into the litigant? You must come, you must be present. When I'm marking documents, I must go through you and we read through because eventually you'll have to refer to them in your witness statements. When I'm drafting the application, I will not send you the affidavit for signing. Sign this page. No, we'll go through it together. At every step of the way, engage the client. It's the only way they will be able to appreciate. Otherwise, lawyers don't sweat. If it doesn't see you sweating, it will be very hard for the clients to pay. I'm almost done here. The other thing is embrace software, guys. There's so many people that have come up to develop these softwares. There's a billing software. I've seen SmartCase. So with these softwares, you are able to track. Because when you leave office, if I'm going to court for a certain matter, I will indicate I'm out of office, I'm in court. When I come back, I'll say I've come back. It's just a click of computer. It will be able to, because we lose so much time. You lose so much time in meetings. When a client knows that you charge them, and when you come and indicate that you've come back in office, the software sends a client a message and says, I'm from court, you've updated it, the matter has been adjourned to this and this date. Then the client will not ask, those hours, where were you? 1, I was with you at court. 2, I was in court. When I go for a meeting with a client, I will immediately turn it on and say, meeting with so-and-so. So when I come back, and I will set it. So this, I find that the software helps us to track the hours that would otherwise have gone unrecognized and unpaid. So I think embracing software is a very good thing. It also helps you to track how much the client has paid. Clients have a tendency of saying, but didn't I pay you this much money? Even you probably don't have a receipt anymore. Most lawyers, it's one-man law firm. I have my books, those are my clients, I know them. But if a client comes up and says, but I paid you this much and you don't have the records, it helps you to track how much a client has paid, how much you're spending in disbursements, how much you should charge, how many hours you're spending on a case, how much work what activities have you done on the case. So I think embracing software is one of those things that we would adopt in the industry. Then lastly, I think distinguishing yourself. As joking with my colleague here, and I was telling him, I have no problem with a lawyer practicing everything, You can practice everything, but some lawyers, honestly, we find you at police, we find you in Wakiso, we find you in criminal, we find you in civil, we find you in family. How are you going to concentrate on all this? And I'm not saying that lawyers cannot manage, but how are you in what field are you distinguishing yourself? You can't possibly do everything. Even doctors, we all know, if I want to do this, I'll go to Dr. So-and-so. I was talking to a professor of mine recently, and we're talking about markets and economy and everything. And I was telling him, but you see, for us lawyers, we are regulated by the rules. And he said, yeah, you're regulated by the rules, but if I had a criminal case, and I really, really wanted representation, I wouldn't have a problem paying Mr. Makdusman Kabega 300 million to represent me in that case. So I think what I've learned over time, over the short period of time I've been here, is you need to distinguish yourself. Know what you're good at. You're in immigration, you're the one applying here. Honestly, if you don't, then you're all over. And the market people will only be willing to pay a certain price for a particular lawyer because of what they can do, where their strength is. So I think distinguishing yourself is the other strategy that you would do to improve your billing and costing. So from what I've presented today, I think we know the law is there to support us, but us as lawyers, we should also learn. It's a combined effort. Let's learn not to to undervalue and undergrade the profession. You know, I know we all want money and we're all in the industry for the same thing. But when you undervalue or charge much, much less, it's only not to the disadvantage of the person next, but also the many other people to come. Then the other comment I wanted to make is I can't say I interact so much with the lawyers in the other jurisdictions, but I have in the Kenyan jurisdiction and the Tanzanian jurisdiction, and I can assure you that as Uganda we are doing so poorly in terms of earning and billing. And guess what? When the last time I was in Nairobi, I asked this lawyer and I said, how many? I said, you know, for us in Uganda, our problem is that we are too many. And then I asked her, I said, how many people are on the roll? And she told me at that time, like 27,000 lawyers. And I said, well, at that time, I said, we are only 5,000 or 7,000 or around that. And I said, okay, that's not the problem. It's because for them as a combined effort, they know what they want. Those lawyers are no joke. So let's be like the Kenyans, let's be like the Tanzanians and fight this noble cause. That's all that I had to present today. Thank you so much for listening to me.
Thank you very much, Jacqueline, for a very good presentation. Thank you for the effort you've put in. And thank you for being among the ladies when we ask you to come and support the CLE activities. Jackie is one of those people who always comes in either as a dangerous substitute or a substantive presenter. Thank you very much. Now, a few comments on the chat. I'll just read them out for you. One is from Francis Dungu. Good presentation. And Anthony Arinaitwe has this question for you, Jackie. Could Jackie be pleased to share the software provided for tracking the client, payments, and time spent? I hope not for free.
Anthony, I can share with you the person and that person is actually in this room, the person that built our software. So I can just provide a contact with him. Please stand. He's here. You can please introduce yourself for people to know you.
Thank you, Jacqueline, and thank you, Senior Counsel. The software is an initiative that was introduced by a man called Osbat, and he has sold the same software to various persons. So after here, I'll be able to share the contacts for the company, and it can be shared with the other members. Thank you. My name is Nicholas Murere.
About to laugh about that you have not introduced yourself by name. Then the next question is from Ruth Chijambu. Can you please provide the contact in the chat of the software? You can see the software has become the software. If you can, Nicholas, do get in touch with ULS, and maybe they can help you get to the lawyers. It looks like it's a hot potato now. Then Senkumba says, Jackie, thank you for your presentation. However, advocates in Uganda, we are pursuing a small economy and does not enable one to specialize, hence advocates being everywhere. I think that's just a comment. But for the rest, from Kurenza Monica, from Lydia Ochengo Bo, all of them are just saying, thank you, very good presentation. So once again, thank you very much, Jackie, and I think we can release you. Thank you very much. When it's the last day of any training and it's the last presentation and the hours are running, we always cut to the chase or to the bone. allow me, ladies and gentlemen, now to invite Richard Omongole, who is going to lead us in the next presentation. And Richard Omongole is going to be talking about litigation, intellectual practice litigation. Welcome, Richard. Thank you very much.
Thank you very much, Senior Counsel. Good evening, everyone. People are quiet then. At least let's all stand up first. Let's first stand up and see whether you're all still awake. You know, it's not good to present to people who are all quiet. If you're happy and you know, clap your hand. If you're happy and you know, clap your hands. If you're happy and you know, and you really want to show, if you're happy and you know, clap your hands. Thank you. Now I know that the people are awake. Yeah, when I was first contacted to make a presentation today on this issue, thank you. I'm being taken through the nitty-gritty of technology. Yeah, so when I was contacted, I don't remember the name of the person, but I said, Mr. Mole, we want you to come and make a presentation in the training in respect to intellectual property. And so I asked him, what do you want me to say? And the person also said, you just come and give us your experiences. We say something. I said, okay. Then I don't think I have that much experience in intellectual property and so on. But then they say, no, Mr. Senior Counsel, James Semgenyi, has trust in you and he thinks that you should do it. So when they mentioned the name Senior Counsel James, I said, okay, I think this is now where it comes. When Senior Counsel has commanded, I think I have to go and do my homework. And that is the topic. And I think I asked for a kind of an outline, which was sent to me. Technology is not oh, thank you. So I was told I just needed to look at the various aspects of intellectual property and also to be able to look at issues like enforcement, remedies, defenses, and so forth. And my experiences following I think the recent case that is doing a bit of rounds, largely the Proline Soccer Academy and the MTN, which I handle with the Kampala Associated Advocates and so forth. So basically, the law, we all know, there's a law that guides intellectual property, each of the aspects. My presentation begins with a patent. I think the patent under Section 2 of the Industrial Properties Act defines it as something that is granted to be protected, or an invention that has to be protected. And when you look at the various provisions of the Act, you see that Section 9 clearly says it's to mean something that is new, which involves to be the inventive step, or is industrial applicable and not excluded by Section 8, subsection 3. And so forth. And some of those patented will want to qualify to be able to patent, then the patent must pass the test of novelty in accordance to Section 10. That is, it should be new and unspated and so forth. So you don't just come up with something in respect of, say, I think the product we have here is water. So you don't come up with something in a bottle of water and you say, I want this patented for whatever reason, it must pass the test. And the other, of course, is it must be inventive in accordance with that section 11. And then industrial applicable, that it's something that can be used and capable of being used in any kind of the industry and so forth. Those are some of the aspects. Of course, there is controversy. Maybe I should go back. I think you all remember that product, the picture, Cont'D. Cont'D, my real first involvement with the patent came under Cont'D. It was a very, very a trying moment and an involvement that when I was listening to Natikonda, I wish she had discussed earlier. Before I got involved, I think the billing, I would have had a holiday in Barbados. So, of course, there must be an inventor to a patent under Section 17 of the Act. And the 17.2 as well provides for a kind of a joint ownership. And when you look at Section 17, issues of joint ownership were very, very prominent in the Cont'D battle between Professor Gwang and Imbarara University. And under clause 3, obviously it states that a variance independent investor can come up with some invention. The first to file the application for registration of a patent will be the owner of it. When we're battling the Cont'D issue and so forth, at one point it was almost lost as to who was the original inventor of Cont'D and so forth. The only person who was very sure of the invention of the patent was Professor Gwang, because he knew how he started it, he knew what he did, and he knew every step of it. But there were other players within the university and even another institute that was within the university that had contracted him to undergo certain trials and so forth. So there was confusion as to what stage and who really had invented the patent. And if you remember, during that confusion, there was a lot of exchange of notices of intention to sue. The university was writing to the Professor Gwang and saying, we are going to sue you. Professor Gwang instructs us to write to the university that we are going to sue you. And another party writes to Professor and ND and says, we are also suing you. So that confusion, I think, because everybody, but for us, clarity was definitely provided under the subsequent provisions, sections 19, and especially 19, clause 6. It provides that inventions made without any relation to the employment or contract of service or without use of the employer's resources belong to the employee. You know, that provision came in very, very handy during that fight. Unfortunately, the university and the others could still not understand because of the confusion at what point was Cont'D discovered. Was it when Ogwang was lecturing at the university during the trials, or he did this outside the university and so forth? And obviously, everybody, including the public, what everybody seemed to know was that simply when you're an employee and you make an invention within the university, it is automatically a property of the university. So that, and you know how the rumor mill, and even in the legal circles in Uganda can go around. Everybody was saying, what are you people trying to do? That is from Bara University. And that actually caused there are a certain group of people under that case. They call themselves advocates for people, and another versus National Drug Authority in that miscellaneous application to rush to court. They went to court after National Drug Authority because there were a lot of developments on a daily basis. COVID was ravaging, the world was ravaging, and here was hope being provided by a Ugandan professor. And the developments were on a very fast pace, even from a number of foreign countries and pharmaceuticals. And so forth. They wanted to know, well, what is this? What is Professor Wang talking about? And so forth. So this group just rushed to court and said, National Drug Authority, how can you approve? Because National Drug Authority had issued a press release saying they have allowed the production of Covidex. Of course, because of National Drug Authority could not go through the various steps that they normally usually take to approve a certain drug. COVID was ravaging the country, and there was a need to see something come up. So they made a press release allowing the production of Covidex, allowing a Professor Wang. That group rushed to court and say, no, we want a judicial review. You cannot give out the patent of Covidex that belongs to the university. And the people of Uganda are losing a lot of resources. So Honorable Kasbante and his group, luckily enough, Justice Musa Sekana reviewed it. We went on the aspect of judicial review, and as you can read, the judge did not think that that is a case that merited judicial review. First of all, for the advocates for people and the Kasbante, I don't think we owed any duty by National Drug Authority and not even Professor Wang for them to be heard before the approval of the drug and so forth. So that is when it really came out, and for us it was a good decision because the university that was claiming the patent shied away, but they appeared to be coming through that NGO. Probably they did not want to directly take on the professor, one of their own. And we also had to play a bit of politics in it because we were telling the university, we were telling the country that Professor Wang is a gem, not only for Mbara University, but for the whole country. Because many people actually benefited, used Covidex, and many people testify that it was helping relieve the symptoms of COVID without necessarily going through the clinical trials that it was supposed to, and so on. When you go further within the law, you find that basically the section 25 and 7 almost recall that issue of the rights of an employee versus employer in respect of ownership of a patent and so forth. So I think that case and the actions, luckily now Professor Wang seemed to have, he was not only a pharmacologist, but seemed to have had a good grounding on the law of patents. By the time he discovered Covidex, he had gone through these processes. So he knew to what extent he would involve the university, he would involve the funding partners, he would involve other people. And he kept secret his formulation, which were patentable and so forth. So that matter was resolved in his favor and so forth. I have also looked at certain areas within the law Of course, the Act takes us through a lot of other processes on how to register and so forth, the patent within Uganda and the region and so forth. I didn't want to really take you through the various provisions one by one with Spanish. It's an act with over 100 sections and so forth. But I looked at what I consider to be other court battle areas in case you're interested in a litigation in this area or you're preparing yourself for a court session. So when you look at Section 90 of the Industrial Properties Act, Section 90 seems to provide another area of contention as when a patent, a design or utility model can be reversed. So even after going through a certain stages and so forth, you know, they usually lawyers who look at things from that perspective and say, okay, we have this process seem to have been concluded, but it was not concluded properly. So they come in. So the provision seems to say you can go in for certain reasons, and the period, unfortunately, is provided. It has to be within 12 months. In the Professor Wangi's case, actually, that battle is not fully resolved because there's an appeal from advocates for people, and the university also went quiet, and I was hearing information that they wanted to activate the battle because the process of registration is still ongoing and so forth. So Section 92, of course, what constitutes an infringement? When you read through the provision, you look at areas of what are the rights of a patent inventor and so forth, what rights are given to a patent inventor by the law and so forth. And similarly, those rights are also referenced in Section 38 and 79 of the Industrial Properties Act. And those are issues of whether you'll be allowed to reproduce or a design for manufacture purposes, and also importing or offering a sale or selling of certain products and so forth. So you find that sometimes there's also a battle in that area. I'm actually having an ongoing case. That's why I didn't want to give clearer details because it's ongoing. There's a Canadian company, Cont'D Care, and Ugandans are very creative. This company is producing a very good product for ladies' hair, and it's selling a lot in Uganda. So somebody goes to Nairobi and gets a manufacturer in Nairobi and say, try and dig into these products and go in and isolate the various formulas and produce for me exactly the same product I want to sell in Uganda. And they were very successful. They brought the same product. The only difference was the size of the bottling. The branding, the trademark, the contents. Instead, we went to Uganda National Bureau of Standards and they say this is the same product. But the product was different. And the most interesting thing about that case is that the infringer, the person infringing on the patent, because Cont'D Care had registered the trademark and also a patent in Kenya, Canada, and where, but they had not yet done it in Uganda. So the infringing party was the first to go to court. They went to court immediately to stop our client from coming into Uganda, bringing the product into Uganda, and so forth. So as they were shocked and said, but Ugandans have guts. You're the one infringing on the patent, but you're the first person to run to court and so forth. So my clients had to come into the country and they were angry. I said, no, but you've not registered it here. You've not done anything in Uganda, not even a trademark. And say, but we have done it all over and so forth. So luckily enough, we involved the police and we were able to pick up some of the people. And that is how the battle cooled down a bit. But we have an ongoing case from the infringing party, and we also file a matter at the commercial court in that respect. So there are, of course, other provisions within the Industrial Properties Act when it comes to patent and so forth. Section 93 of the Act provides for the remedies. And the usual remedies, we all know. Usually the first one is injunction. When you get the injunction stopping and so forth. When I got injunction for my client somewhere, at that time I did not even think of billing. If I had, so when I thought of billing later, the client had gone back to Canada and was saying, "No, cancel." But you see, it's part of the process. Why do you want to separate it? And so, yeah, the other is, of course, damages or any other remedies that may be provided by the law. But usually, if there's an infringement, either destruction, injunction, or damages. Section 95 provides for a process which I found a bit intriguing, that if an infringing party, you write, like the advocates write in the letters, we are going to sue you and take even the land from your grandfather, grandparents will sue you until that kind of, and the infringing party thinks that this is the threat is actually going to be actuated. The infringing party can run to court for protection and get a protection, and then of course come up with a number of defenses or whatever they think will help and so forth. And you know, that is where it gets confusing, that even the violator is allowed by law to dash to court and say, "Please hold, stop your threats. You're not going to threaten me on this." Section 96 provides for the presumption of use of patented process. And in that, when you challenge and say, of course, if you're using it for whatever reasons, or license or something, or with the consent and so forth, the burden shifts to the infringing party to show it is no longer you, the victim of the infringement, to show. So the burden seems to shift, in my understanding, to the other party. I was asked to say something about expert witnesses. Under the Industrial Properties Act, it's definitely specifically allows that the court may appoint any person with expert knowledge to assist the court and so forth. And I can be called to assist the court, give evidence on and in this case, when we were trying to resolve an ongoing case and so forth, actually we found a team from Uganda National Bureau of Standards very useful, because the expertise to isolate the various formulas and whatever they gave and so forth was very important. Of course, the challenge is that as a lawyer, we expected them to say the infringing party's products is completely wrong, it is what, and all that. But they went and identified all the similarities and so forth. And somehow, yeah, it was helpful to show that these guys also did their research and they were able to do that. Yeah, within the Industrial Properties Act, of course, the Part 17 and all the others are about enforcement, enforcement procedures and so forth. I just wanted to point out that the Act also repealed the Patents Act, and especially for us senior counsel, it is important to know that some of these laws sometimes I should share with you a small experience. And it happened even this morning. I asked one of my members, I said, "Can you get me the Patents Act law?" And they brought me the act. which was repealed. So it fitted in. I said, but you see, now you're going to say senior counsel presented. Sometimes these laws are amended. When I was at law school, it was a patent act. Now you have the Industrial Properties Act. I think senior counsel again, you will testify that some of these changes, so it is important to look at those repealing provisions. One time I went to a court in Soroti and we had oral submissions. There was senior counsel there, very senior. He was submitting vehemently on statutes of general application, very old laws, and both the magistrate and I, myself, were a bit embarrassed and say, how do we now tell senior counsel that law is repealed and so forth? So I had to find a way. And he was grateful enough and said, oh, you see, some of these changes and amendments. So it's really the reason. And I know that quite a number of people are still confused with that and so forth. Of course, there are other issues like the industrial design as provided in the law. There's a bit of litigation that has happened in that area in the case of Migo Industries and Trading Company Limited versus Ryder International and so forth, where the dispute was about the design and of gumboots and so forth. And the court was, Justice Mubiru was of the view that it was an infringement of the industrial design and so forth. The other part I was asked to look at was trademarks. As you can see, a definition of a trademark within in the Anglo Fabric Limited, and another trademark, Justice Bamwine call it a sign, a symbol, a phrase, or a product feature, or any combination of those that distinguish in commerce the goods or a service of its own from the others. Of course, a trademark as guided by the law, the Trademarks Act, and so forth. It's you must show that you have a distinctive product, and so forth. And I think all as practitioners, you might have come across the battle. I just brought the photos to try and illustrate when that case was ongoing. Cafe Javas and Java House, I was one of the people convinced that there was confusion. I'm a very good consumer of coffee, so I used to go to both somehow, and I was convinced that there was confusion likely to be created through the use of the word Javas and Java House. But Justice Madrama, in that case, did not agree, and he said that the trademark of Java House and Cafe Javas are very different, that the use of the words Java in the combination with otherwise give the distinctiveness of the trademark and so forth. So you see, sometimes in litigating on the intellectual property, especially trademarks and so forth, depending on the judge, a number of them, you find the judge will just go for one word and throw out the other in the mark, a very small feature to try and distinguish the mark and so forth. And the law clearly states that is the position. I went in a little more into part D of what we call the image rights. The image rights, I think, were not all that very pronounced in our litigation over the years. But the law is slowly developing. It's still a bit of a gray area, but the law is developing around it and so forth. Okay, thank you. So you'll find that it is not yet statute founded in Uganda. You cannot look into the intellectual property laws and say the image rights is defined here. It's guided and regulated in this manner and so forth. However, image rights they've been defined as image is used to describe that individual, describe rights that individuals have in their personality, which enables them to control the exploitation of their name or picture. And Justice Mubiru, in a recent decision, Proline Soccer Academy Limited versus MTN and other, in a matter that were involved, and involved largely the Uganda Cranes players. I was involved in that case at the hearing stage, and so forth. I was not initially involved in the drafting, which was I must give credit to my colleagues, Muema and Muema and Company, and I think Mukasa of KSMO. They seem to have initiated the drafting and so forth. So I took over the court hearing process and so forth. So the argument in that case was MTN got out, looked for one of the advertising agencies, told the advertising agencies, please, we need to use the images of Uganda Cranes players for our advertising. If you remember, you might have seen at one point all over the country or Kampala, billboards of MTN with the Uganda Cranes players and so forth. So such and such he contacts Proline Soccer Academy and say, we know that you're involved in this as a company. Can you procure for us players? So Proline Soccer Academy procures 11 players of the national team. And they went for a photo shoot in Nambole. It was not during a match, but it was basically a photo shoot. And their images were used in a contract where MTN paid Proline for 1 year. But while that contract was subsisting and was about to expire, MTN then signed another contract with the Federation of Uganda Football Association, FUFA, which gave them all the rights of all the players of Uganda Cranes as long as they're in the pitch and the Uganda Cranes jerseys and so forth. And it was part of the sponsorship package. So MTN continues for 5 more years using the same images that were taken during the Proline contract and using them without paying Proline. So Proline says, no, but you're using our images out of an arrangement and so forth. So Proline goes to court, and it was quite a battle. There were a lot of applications. At one time, we had to remove the advertising agency and said, for us, we are willing to be witnesses. And when we got them out and even paid the costs of getting them out, they refused to be witnesses. And said, no, we do not want to jeopardize our relationship with MTN and so forth. So we went on. When we finished hearing the plaintiff's case, the defendants, MTN, then go for a third-party notice. That is how the Federation of Uganda Football Association comes in and say, we have a contract. Can you come and indemnify us from this attack on the use of the images of the Ugandan national team players and so forth? So again, protracted, took about a year or two on the third-party issues until it was resolved. And FUFA comes in to defend. And when they came in, they really came in very vehemently. They even went past the MTN, the defendants, and took over because they had given MTN the impression that they own the image rights of these individual players and so forth. And that is where the battleground was drawn, whether FUFA actually owned those rights and could give MTN the rights that they purported to keep them and so forth. So a lot of research, of course, you know, the law here had not yet developed on the issues of, because it's based on common law. We don't have a statute to that effect and so forth. So we had to do a lot of research. And Rooney's case came in handy. Those the Manchester United fans know Rooney better than the Arsenal fans and so forth. Sure. So the Rooney's case, that case came in handy, and it defined what an image right of a player was, clearly. And Justice Mubiru agreed wholly with that definition. And in his decision, I think he agreed that the image of a player is owned by the player, because I think Rooney had gone through that in Wales and so forth, where they're trying to say, no, the company owned the rights and so forth, and he said no. When they went into court, and the company that represented him, I think, said it was said to own the images on behalf of the player and so forth. So Justice Mubiru has ably redefined the issue of image rights and brought it down home in Uganda in that case, because it brings out a lot of aspects that we're just reading or trying to borrow from the foreign jurisdictions and getting from. But in this case, he really came down. And yes, we supported in our research both sides, Kampala Associated Advocates and Umongola Company Advocates, because it was really a very fierce battle. It was a lot at stake. So, and the judge himself put in his time. If you've read the decision, it's quite a volume and came in. So there are a number of aspects, as you say, the image rights are rights of an individual, and they consist of two types. That's the privacy and the publicity rights and so forth. So in Uganda,